Very good. Thank you, Anna. Hey, did you know that this is Constitution Day? It's true. We wish a happy Constitution Day to Lubbock attorney Chuck Lanehart. Good to see you.
Happy Constitution Day to you.
I feel a little bit more, I don't know, patriotic a little bit today. I didn't know this, but the local bar association does presentations about constitutional rights and things of that nature for young people in high school groups. Tell me about that and how it got started.
It's called Now You're 18, sponsored by the Texas Young Lawyers Association. We've been doing it for decades. Essentially, we just go out to the schools whenever they will have us and speak to mostly seniors about, hey, you're about to be an adult. Here's what to watch out for. Here's what your rights are. Here's how you can get in trouble. Those sorts of things.
Important stuff. Important stuff. And you're a criminal defense attorney.
That's right.
And I want to know, as we get into that sort of concept of Bill of Rights and what your rights are and things, do you get a lot of what we call the law and order effect around here, where people watch things on TV and they think they know how the law works and it may not necessarily be right?
Absolutely. A good example is I have a lot of clients who come in and say, you know, they got to let me off of this charge because they didn't read me my rights, my Miranda rights. And that's really not how it works.
So how does it work? So on TV, it was almost one of those things that seemed like they almost have to do it as soon as they see you and they talk about putting the handcuffs on you. But that's not always how it has to go, right?
Miranda is based on the Fifth Amendment, which gives you a right to remain silent and not give any evidence against yourself. The Miranda decision was a United States Supreme Court decision from the 1960s, which said if you are in custody and the police want to question you about a crime, they must read you your Miranda warnings. They must warn you about what your rights are before you can answer those questions. If they don't read you your Miranda rights, then your statement cannot be used in court against you. If you do give a statement after those warnings, then it will be used against you.
Gotcha.
So, it's only when you're in custody, if the police just come to talk to you about a crime and you confess to it, your statement can certainly be used against you, even if they don't read you their Miranda warnings.
Yeah. Now, I guess a lot of the Bill of Rights, so we can go through it point by point, but there's I think a lot of illegal search and seizure rules that might or might not come into play in certain cases as well, right?
Criminal defense lawyers deal with the Fourth Amendment probably more than any other part of the Constitution. The Fourth Amendment protects us against unreasonable searches and seizures. And honestly, there are a lot of unreasonable searches and seizures out there, but some are legal and some are not. Happens a lot in drug cases, happens a lot in DWI cases, driving while intoxicated cases. Usually a police officer must get a search warrant to obtain evidence against a suspect in a crime. There are lots and lots of exceptions to that, and that's what we deal with all the time.
With those exceptions, do you think the Fourth Amendment is clear enough on how that should go? And as a defense attorney, I think you may have one thing, but are there ways to make it more clear for everyone involved in how that should operate when you're dealing with a potential crime?
Well, the advice we give our clients is just say no to searches. Because it's like the Fifth Amendment, like the Miranda rights.
Right.
If you don't agree to the police doing what they want to do, you have a much better chance of a good outcome on your case. And no, the Fourth Amendment is not clear. That's why the courts have interpreted it over 300 years now, and it's changed over the years in terms of what the Fourth Amendment really means.
What else in the Bill of Rights are the courts having to give folks a little bit of leeway one way or the other?
Well, there are 4 amendments to the Constitution that deal with a person's rights in the criminal context. The Fourth Amendment deals with unreasonable searches and seizures. The Fifth Amendment deals with a person's right to remain silent and also right against double jeopardy. The Sixth Amendment right is all of a person's rights dealing with a fair trial, the right to a fair trial, the right to a lawyer, the right to a speedy trial. those sorts of things. And then the Eighth Amendment has to do with a person's right not to have to make excessive bail and to be free from cruel and unusual punishment. Those are the primary parts of the Bill of Rights that criminal defense lawyers use and that people who are accused of crime benefit from.
We hope you benefited from a little bit of a history lesson, a little civics lesson today from Chuck Lanehart, defense attorney and former KMAC reporter back in the day.
That's right.
He's good on TV. Thank you, sir.
You bet.